Alrighty, ladies and gentlemen. Good evening to you guys. We've moved on to chapter 5, where we're going to be discussing probable cause and arrest. So, as an introduction, an arrest is reasonable under the Fourth Amendment when the seizure is supported by probable cause and the arrest is executed or carried out in a reasonable manner. So, this chapter is about arrest. We've talked about probable cause and searches, but there's also probable cause that is required for an arrest, or what we call that seizure. Seizure is an arrest. That's when they take you. So when you're seized, when you're stopped, when you can't move, or when they take you somewhere where you don't want to go. So an arrest results, and we'll talk about arrests themselves. An arrest results in an individual's being taken into custody and is more intrusive than a reasonable suspicion stop. A formal arrest occurs when an officer directly tells a suspect that you are under arrest. In a de facto arrest, an officer does not directly announce that an individual is under arrest, but a reasonable person will believe, based on the totality of the circumstances, that he or she is under arrest. Now, I heard you. I know you heard me say a word de facto. Just take this break, take this point, take this time to explain to you two words, or two, yeah, two words. One being de facto. De facto means as a matter of fact. So it's not something that's stated, but it's something that we can deduce from the facts. So that's why we have an arrest, which is and we have de facto, and then the opposite of de facto is de jure, something that's by law or something that's in writing. So of course there's the arrest where they say, "Hey, you are under arrest." Where okay, I'm under arrest. But then there's the de facto arrest where the totality of the circumstances essentially says that I can't go where I want to go. He didn't tell me I was under arrest, but I'm being carried away in the back of a police car. So an arrest does not require that they tell you you're under arrest. So in a de facto arrest, you should know you're under arrest because you're in handcuffs and you're in the back of the car. Now, normally the police are going to tell you you're under arrest, but that doesn't always happen. Now, now that we know what arrests are, let's talk about probable cause. Police officers possess probable cause for an arrest where the facts and circumstances within their knowledge and which they have reasonably trustworthy information are sufficient to warrant a person of reasonable caution in the belief that an offense has been or is being committed. That is like the book's definition of probable cause. So, the one crazy thing about probable cause and these definitions that we're talking about is none of them are the same. You can go to different law books, and the definition of probable cause will be different. It is a fluid concept, and it is not altogether defined perfectly where it's consistent. So probable cause kind of changes, and that's crazy because probable cause is the basis upon which you can be taken hostage, where you can be arrested and charged with the crime, and you can be held based upon a standard that's not definite. So I'll read that again. Police officers possess probable cause for an arrest where the facts and circumstances within their knowledge and of which they have reasonably trustworthy information are sufficient to warrant a person of reasonable caution in the belief that an offense has been or is being committed. Probable cause is based on common sense and on practical evaluation of the totality of the facts and cannot be reduced to a set of rules or to a mathematical formula. In making this objective, when we talk about a reasonable person, courts recognize that officers have special expertise. Probable cause is based on probabilities rather than certainties. Okay, which is scary. So, a police officer may rely on his or her five senses in developing probable cause or to conduct an arrest. He or she may develop probable cause through sight, sound, smell, touch, or taste. Probable cause may be based on hearsay or secondhand information provided by eyewitnesses, crime victims, or police officers. Hearsay information also may come from informants. And we'll talk more about exactly what hearsay is as well later. The traditional approach for evaluating whether an informant's report constitutes probable cause is what we call the Aguilar-Spinelli two-prong test. The United States Supreme Court held that probable cause may be based on the hearsay report of an informant so long as the informant satisfies the veracity or truthfulness prong and the basis of knowledge prong. So, in other words, are you telling the truth? And two, do you have were you are you even in a place where you know what happened, where you were there, you witnessed it? So, in 1983, in Illinois v. Gates, the U.S. Supreme Court modified this test and adopted the totality of circumstances analysis. Various states, nonetheless, continue to follow what we call the Aguilar-Spinelli test. So, what that talks about, the probable cause section we just went through, just essentially tells us what can be used to develop probable cause. So we have your five senses: what you smell, what a police officer smells, what they touch, what they see. Then we also have what they hear, specifically what they hear from an informant. When an informant tells them something, if this is an informant they've been working with, and when we apply the Aguilar-Spinelli test, is this a informant that is truthful? And two, is this an informant that we know or have reason to know has been within a distance or within a proximity of the crime to know what's going on, to be able to say this is going to happen. They deal drugs there every day. I work there. I'm an informant. I work there. I know what happens at 5 o'clock every day. A drop is made. So that's what we talk about, the Aguilar-Spinelli test. So let's move on. Reasonableness and arrest. So, and of course, an arrest must be reasonable. So it must be based upon probable cause, and then it must be reasonable. The Fourth Amendment, as we have seen, requires that an arrest be based on probable cause. The Fourth Amendment also requires that an arrest be carried out in a reasonable fashion. So what that means is it can't. When we talk about reasonableness, especially with use of force, sometimes anytime you have an officer that's overstepping his bounds, they're arresting the person, and the person's on the ground, but now during the arrest, they're kneeing the person in their back, and they're taking extra shots at a person. That officially makes the arrest unreasonable. In other words, you have to throw the whole thing away. But we'll get to that when we talk about how to keep that evidence out, about what we call motions to suppress. When we talk about what would that be? When we talk about the what happens when we now challenge whether or not there's been probable cause, or when we try to keep evidence out. So what those remedies, what those remedies are when our rights have been violated. So probable cause, warrants, and the courts. The Supreme Court has expressed a preference that arrests be based on a warrant issued by a judge or a magistrate. This means that the police must appear before a judicial official and establish probable cause to arrest an individual. The warrant procedure establishes that the police have probable cause to arrest an individual. In the case of warrantless arrest, the Fourth Amendment requires that the individual who is experiencing an extended loss of his or her liberty is entitled to what they call a Gerstein hearing to determine whether a reasonable person will believe that the suspect committed the offense. So we're going to talk about instances in which the officers don't need to go get a warrant for your arrest. So, of course, the Supreme Court has a very serious lean where they say, hey, we prefer that you get a warrant based on probable cause. So, in other words, you go to a judge to explain the basis for probable cause, and you get permission from that judge in the form of a warrant to now go arrest this person. Honestly, that is the safest way for police to do things, because now you've taken it to a judge, to a disinterested kind of referee or person in the middle to state whether or not there's a basis for arrest. So you have an outside third party and I'm speaking from the point of view of a police officer, but you have that outside party who you're now talking to about your case, how you feel, what you saw, and that person can now give you permission to now go arrest based upon the information. So you have an outside party looking at it to say, "Yep, that's enough probable cause. I'm going to grant you. I'm going to grant your request and give you a warrant." Now, when you don't do that, when it's a situation, and we'll talk about the exception to that general rule that the Supreme Court wants you to go get a warrant first. There are exceptions. So there are situations where the cops can actually arrest you without a warrant. But even without a warrant, there still has to be probable cause. So, and the defendant is entitled and can and actually can request a Gerstein hearing, where they essentially have the court, even after their warrantless arrest, determine whether or not there actually was probable cause. So just because an arrest falls under an exception to the warrant requirement doesn't mean that it still doesn't have to be based on probable cause. It actually does still have to be based on probable cause. So the police officer in their arrest, they still have to explain the basis for their probable cause. So it just doesn't go away. So a person is brought before a magistrate in first appearance, and that officer still has to explain uh, to the magistrate or judge why they arrested the person. So it still has to be explained, and even if the judge, at least at the initial hearing or at the Gerstein hearing, uh, approves of the arrest and says, okay, there was probable cause. There are other remedies later on, such as a motion to suppress, where this person can still, as a defendant, challenge their arrest. So, but we'll talk about that. Arrest and warrants. Arrests for let me see, make sure I get it. Okay. Arrests for felonies in public do not require a warrant. Arrests for misdemeanors committed in the presence of the police also do not require a warrant. So that's one of the many exceptions. So just like with the with the with the exception to the warrant requirement with search and seizure, where we talk about plain view, it's kind of the same thing. If I'm a cop and I'm sitting there watching you, kid, and I see you shoot someone, at that point, I don't have to run to a magistrate to say, "Oh, I saw this person shoot someone. Can I get a warrant to arrest him?" No, at that point, I can arrest you right there. It's almost the same thing as a plain view. So if you commit a crime in front of me, and as a police officer, I witness you commit a crime, I can arrest you right there. If I'm walking by and you're smoking weed or you're rolling a blunt in your car, not only do I now have probable cause to search you and search to see if there's any more contraband, but based upon what I'm seeing you do, I'm watching you be in possession of contraband, so I can arrest you right there. So that's one of the exceptions to the warrantless arrest, the rule requiring that you get a warrant for before you arrest someone. So arrest in the home. Peyton v. New York held that absent consent or exigent circumstances, consent or exigent circumstances are also, once we see later, they are exceptions to the warrant rule. But Peyton v. New York held that absent consent or exigent circumstances, an arrest warrant founded on probable cause is required to enter a house to arrest an individual. Okay, what are exigent circumstances? The U.S. Supreme Court has held that the police may enter a home without an arrest warrant or search warrant when there is probable cause that there are exigent circumstances or a situation of urgency in which the police do not have time to obtain a warrant. So that's essentially a definition of exigent circumstances. A situation of urgency in which the police do not have time to obtain a warrant. So that means there's something obviously going on, even though they may not be able to necessarily see it with their eyes, because of course, if they can see the person committing the crime, of course, that is an exception. But the situation where they may not be able to see it, but they know something's going on. So if the police are outside the house, they're knocking on the door, or they're there to make a welfare check on a victim or a past victim of violence, and they can hear a person getting thrown around and beat up in the apartment and say, "Please help me, help me. He's trying to kill me." In that situation, they don't have to go get a warrant to now bust in the house and make an arrest or save that person. That is an exigent circumstance. So that's what that means. It means it's something of immediate urgency where a warrant is not required because of the immediance of the immediance of the situation. Um, Courts have recognized exigent circumstances where there is hot pursuit, a threat of public safety, probable cause of the destruction of evidence, a threat that the suspect may flee, or the need to assist an individual in peril. So the information I just gave you, or the hypothetical, was basically that last instance, or that last example. So if a person is in peril, if we hear someone getting beat up, or we know someone's getting roughed up, or we hear a gunshot, at that point, we're going to kick the door down because someone's obviously been hurt or is being hurt. So we're going to save them. And situations where we're outside and know we're knocking, and they know the cops are at the door. So we have reason to believe that now they're probably flushing dope down the toilet or something like that. That would be an exigent circumstance. So, hot topic these days, of course, is deadly force and arrest, because arrests are seizures. Now, deadly force, that means when the officer uses force against the person and it results in them dying, that is a seizure. So that's the ultimate seizure. That means now I'm not just arresting you, I'm ending your life, and I'm seizing you right there, stopping your heart, essentially. The common law fleeing felon rule provides that police may employ deadly force to apprehend a suspect who flees the police. But of course, that has been deemed unconstitutional. When a person runs, you can't shoot him in the back anymore. That's for law enforcement. This was modified in Tennessee v. Garner. The Garner court held that where a suspect poses no immediate threat to the officer or threat to the public, the harm resulting from failing to apprehend him or her does not justify the use of deadly force. So, in other words, just now before the Garner case, a person takes off running and the cops pull out a gun and can shoot him dead right there because he's running. Even though he's obviously not posing a threat, but he took off running and we can't catch him, so we're going to shoot him in the back. The Garner case overturned that and said, that is now unconstitutional. You cannot shoot a fleeing felon unless unless they are obviously an immediate danger to others or to you as an officer. So of course, that means that all they have to do is prove that, okay, I was in fear of this person was in danger, and they can use deadly force. But of course, we always talk about the proportion of the force that's used. So if a person is, what we see, we have always had these people pulling out cell phones or going in their pocket and getting shot by the cops, and they always have the same explanation. Oh, he was reaching for something. He was endangering me, so I shot him. And as we see, the courts have, for the most part, let law enforcement get away with that. And so it's a very dangerous thing. But so remember, deadly force is also a search and seizure. So it's tested under, well, not a search and seizure, it is a seizure. So the test that applies to deadly force is the probable cause, whether it's probable cause and whether it was reasonable. So we have to ask ourselves whether or not that use of force was reasonable. So in determining whether or not that use of force is reasonable, we have to ask ourselves first and foremost, was it proportionate to whatever the I guess threat was, or whatever yeah, exactly that. Whatever the threat was, or whatever their officer thought was going on. So if a person's walking down the street, of course, if a person's coming at an officer with a knife, with that situation, that is deadly force. They can return with deadly force. But is it reasonable if a person's just reaching in their pocket in general that a cop shoot them? I believe they should at least see what comes out of his pocket before they just blast the person. Um, so all that is under the reasonableness umbrella of the search of the probable cause and arrest. So non-deadly force. So we have deadly force, which we talked about, which is obvious. That means someone is dead. Then we have those situations where the police use force. Now, it's still the same test. What is reasonable in the certain given the totality of the circumstances. The police employment of deadly force as well as non-deadly force during an arrest, investigative stop, or other seizure is analyzed under the Fourth Amendment reasonableness standard. The question is whether the police officer's actions are objectively reasonable in light of the facts and circumstances. So that means we have to look at everything under an object. I'm sorry, under an objective standard. I don't know what's wrong with my words tonight. but that means, is it reasonable under the facts and circumstances? So once again, we have to call proportion into play. If we have a person that's just kind of resisting, of course, they got to use a little bit of force to get them down, and they get them down. And this is what we often see in videos. So a person may give resistance, okay? Of course, and the officers get the person down on the ground. Now they're on the ground where they're subdued, they're cuffed. But what we see is we have officers still giving shots or still hitting a person. We have a person tied down in a chair. Or in some type or strapped down to some type of device where they can't move, but you got officers still wailing on the person, or you have 4 or 5 officers on one person, and you have other officer comes in late, and now they're throwing bowls or throwing shots at a person. That in and of itself, as this is my opinion, but that is not reasonable. So the point is the police officers' point or their purpose for even being there is, of course, to stop a situation. So, or what I say, diffuse a situation. Once it's diffused and they have a person in custody or they have a person subdued, what's the point of continuing to hit a person? So, the police, even though police officers are human and humans have vengeful sides, um, just like regular humans, if I become vengeful and I hit someone because they hit me or I'm mad and I hit them, as a regular person walking the streets, I would get arrested for that. Even though, and the normal human would say, well, that's justice, that's street justice, but that still, um, it doesn't erase the fact that I may be criminally liable for hitting this person. So the same thing applies with cops. Just because you're a cop doesn't mean you now stop being human, and doesn't mean that you shouldn't be held to the same standards as people walking the streets. So yes, you wrestled this person down, or that you've had to chase this person, and you finally caught them, and they gave up. So, but you're mad because you had to run 400 meters. You had to run a race to chase this person down. Now you got him down. Now that you got him down, you handcuffed him, but now you want to throw him a couple jabs just because he made you have to run. That in and of itself is vengefulness. Can't do that. That's retaliatory. So I think any type of force used in that situation is unreasonable. But of course, like I said, these are fluid tests. The concept of reasonableness, the concept of probable cause, and reasonableness of arrest, they are fluid concepts. So from case to case, it almost depends on what judge you're dealing with and what that judge's point of view is. So let's move on. Misdemeanor arrest and citations. In Atwater v. City of Lago Vista, the United States Supreme Court held that if an officer has probable cause to believe that a suspect has committed even a minor criminal offense in the officer's presence, the officer may, without violating the Fourth Amendment, arrest the offender rather than issue a citation. So what that means, the officer has the option to arrest or to issue a citation. So even if it's a misdemeanor marijuana charge, something like a class 3 marijuana charge, you got a dime bag or nickel sack or something like that, or a blunt, and you're trying to smoke, and the cop catches you, the cop can arrest you. So he's well within his legal rights, even though it's a minor crime. The cop can arrest you. Doesn't mean he has to, but he can. I guess that's why they say they're doing a person a favor by giving them a citation in certain situations because it didn't arrest them. So that is chapter 5. So we talked about probable cause and arrest. I hope you got something out of it. And we will talk in depth about it. We'll probably talk about law enforcement and the use of force and what can change. It may be one of the topics of our discussion board coming up later this week. But you guys be good. Make sure you study through the chapter yourself, read through it, use the online resources to kind of review and make sure you got the concepts. If you do not have the concepts, please email me and let me know what is missing. Thank you very much. Bye bye.